your brother, Mr. Justice Chachabuike, your brother, Mr. Justice Gambi, your brother, Mr. Justice Mwongo, sitting separately, each one of them was persuaded that the petitions and the notices of motion asking for conservatory orders raised weighty constitutional issues. That is why this bench was constituted. Those weighty issues await full arguments by both sides for the court to resolve. Number two, the weighty issues are around the petitioner applicant, the deputy president, challenging and seeking to have the impeachment quashed. In the interest of time, I will not restate those weighty issues. They are in the record, but they are there. Challenging the impeachment and seeking to have the impeachment quashed. For the sake of this country, today and going forward, those are issues that must be heard and adjudicated by a bench that has no issues of bias, apparent or real, being raised. So for that reason alone, please accede to recusal. If you set up to adjudicate those issues. So I can't.
I would like to talk about just three aspects on the subject of recusal. And I'll be making reference to the achievements and limitations related that a recent Supreme Court decision delivered on 11th of October 2024. Let me make arrangements. Your Lordship, on my right and on my left, our counsel were involved in this matter where the Supreme Court was asked to recuse itself, which means this is fairly limited, and 5 others versus East African Development Bank. Mr. Ngunyi and Senator support me on the same side, but today on different sides of that decision. When that application was made before the Supreme Court, I do not want to go through all what went on. I want to go straight to paragraph 27, where the court said, having arrived at the inescapable conclusion that we are being accused of bias and working towards an undisclosed indeterminate outcome, we are strongly persuaded that our further participation in these proceedings will not serve the ends of justice, at least in the eyes and perception of the appellant/applicants. Consequently, and inevitably, each of us, his bench, does hereby recuse him or herself from further participation in hearing and determination of the appeal dated 25th April 2023 and filed on 26th April 2023. That's a position that was made just for these petitions were concluded. So, when allegations of bias and working towards a certain outcome permanent for the Supreme Court recently is recused itself. My Lord, I have a decision, an Indian decision. It's called the State of Punjab versus the Greater Pal C. Also, the question of recusal was discussed at length. And again, I do not want to dwell. The whole decision is a very lengthy one. It's about 400 pages. But at page 9, paragraph 16, the court sets the standard that is applied in determining whether a bench should recuse itself. And the test, right? The test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely, and whether the adjudicator was likely to be disposed to decide the matter only in a particular way. The court went on to say, the court has to proceed observing the minimum requirements of natural justice, i.e., the judge has to act fairly and without bias and in good faith. A judgment which is the result of bias or want of impartiality is a nullity and a trial, quorum and judice. Therefore, the constitutional order in is liable to be enforced. Lastly, and this is what is very important, at paragraph 18, the court said in part, however, if there is real ground for doubt, that doubt must be resolved in favor of the accused. So that, my lords and my lady, if you are in doubt whether you should recuse yourself or you should not recuse yourself, that doubt should weigh towards the accused. That decision will be shared. And then the court went on to quash some proceedings which had taken place, the appeal had been determined, and then this one went all the way to the Supreme Court of India. So the court said that that is how situations of bias are treated. I had reference to the code of conduct of judicial officers. I think that's what Mr. Hego was referring to. But my lord, I want to make a business as to where those provisions are obtained from. And those provisions are obtained from the IBA guidelines on conflict of interest in international arbitration. You will find that material is published by the I obtained it from the International Bar Association, and it was done first in the year 2004, and it has been applied worldwide as a guide on determining matter situations of conflict of interest. And it has graded conflicts in several shades. The traffic light shades, there's green, there's brown, and there's the waivable, sorry, non-waivable, green, and the brown. And at clause 2.37, one of the situations that is a waivable conflict is the arbitrator has a close family relationship with one of the parties or with a manager, director, or member of the supervisory board or any person having a controlling influence in one of the parties or an affiliate of one of the parties or with counsel representing a party. Going with the materials, if they are true, that was stated by my other friends, then that situation has already arisen. And therefore, it is a good ground for increasing. But I don't want to take much more that these materials will be circulated. There's much more in these materials that speak towards the case of the situation that is not. Thank you very much.
Sorry, Council, does the court have the benefit of the authority that you have to talk to? Is that based on the IC records? Yes, the IDA.
I also wish to say something on behalf of the second petitioner in 565. If I'm allowed to proceed.
Who are you?
Can you see me?
Your name?
I'm virtual. I'm online.
What is your name? What is your name?
Timodo Teresia Wanjiro Makazi from Kilgoya.
Yes, proceed.
Yes, thank you. I just wished to support that application by just submitting that public perception is everything and it cannot be ignored. I wish to rely on Article 47(1) and Article 50, and more specifically in Article 47(1) is where it says that every person has the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. And more specifically on the part that is procedurally fair. Yeah, if you look at the way the court has conducted itself, of course we are in no doubt that the court is competent enough to handle these petitions, but then again, on the issue of the procedure, we had raised an issue of service, and the court ruled that we should check all documents in the portal. Unfortunately, today, we could not access the e-filing portal. So what one is meant to wonder is why we were told to access documents online, and when we go to the portal today morning, it's not working. Therefore, there is this perception that perhaps there could be something going on, because at all material times, judges shall be impartial. And the issues being raised currently are that there is an issue. Sorry? Okay. So there are issues that are being raised that are raising issues to conflict of interest, whereby we have been directed by the applicants to note that one of the judge has a spouse who has been nominated or appointed by the President of Kenya, His Excellency William Ruto. And I think that is not a question where we should be giving out affidavits. I think that is a question where the judge, the honorable judge, should just come out and tell us if this is true. Then are we going to feel conflicted, so that we can, as petitioner, say, okay, proceed, or no, let's have a neutral bench. The other issue is the issue of another judge, Honorable Justice Murima, being seen No, not the judge, I'm not saying the judge, I'm saying the spouse of the judge being nominated or appointed. That's the issue that has been raised by the applicants. And so we feel, of course, if this appointment was done, will he be able to Murima attending a wedding ceremony, Kingi? So the issue is, and they are long-time friends, will he be able to disappoint a friend? You know, these are the issues that the public is asking, and it's the perception anyway. So in issues such as this, we say these issues are very important and they cannot be ignored. And there's no point of, if people are saying we don't want the bench, it's not so hard for the bench to say, okay, just let's go back to the Chief Justice, please appoint another bench. There's nothing wrong with that. We know the judges are competent enough, but then if the issue of conflict of interest is arising, then the best thing to do before we go to the substantive issues is to pen everything down and say that go back to the drawing board and appoint a new bench. That's all.
Thank you, Mr. Rosh. My name is Daniel Marshall. I do appear for the Interested Party, One Party Democratic Movement Party, together with Mr. Kala. My Lord, I want to say only one short thing and then allow Mr. Kala to conclude, not repeating what has been said this afternoon. My Lord, in 2008, I was involved in a matter which time the Vice President of the country. I appeared before Justice Paul Kihara, and he immediately told me the second respondent is my personal friend, was my classmate in law school. I recused myself. I was sent to Justice Wendy. I appeared before her, and my Lord, she said, the first applicant, a renowned professor, is my personal friend, and I recused myself. My Lord, I ended up in an out-of-court settlement. I do ask Mr. Kala to conclude.
My Lord, my lady, I'll just make one submission. But in light of the disclosure about the relationship between Justice Murima and the Speaker of the Senate, we find ourselves in a very unfortunate situation where the bench looks like it's on trial. Motions of recusal are normally very difficult to prosecute, because the question is, and this is a question that respectfully I want to pose to the bench. Will you feel comfortable? Do you appreciate the fact that so far the events that have taken place, whatever determination that you will arrive in this particular matter, then they are weighty constitutional national matters that affect the entire country, are you satisfied that they will be received well by the public? That's a question that should be in the mind of the judges as they decide whether to recuse themselves or not. Secondly, it is very clear that the only mistake here was that Justice Murima did not disclose a relationship between himself and Amason King, which is out of a friendship and which is not even illegal. But disclosure, the mere fact that there was no disclosure by itself creates suspicion, apprehension in the minds of the applicant. The last question is, if Justice Murima decides to recuse himself, is it the entire bench that will recuse itself, or only one judge will recuse himself? Because I'm convinced that inevitably Justice Murima must recuse himself. Thank you so much.
Your Lordship and my lady,